The Franks motion is from the U.S. Supreme Court case, Franks. It is basically that the officer lied in his application for the search warrant, and as a result, the search warrant is tainted, and therefore the case should be thrown out. Franks was decided, I think, in the 70s. There's a name for it called Franks because it was decided in the 70s, so it's not obviously a novel issue. And as I'm sure you would appreciate, since then, Franks motions are filed all the time. This is just bog standard. So the thing is, he won't get his petition because this is a completely normal, completely bog standard, completely ordinary motion and a completely bog standard, ordinary decision by the court. All right, it's a day that ends in Y. It's not extraordinary. It's not novel. I'm fairly strongly confident the Court of Appeals will deny it, and deny it rather summarily. They get these things all the time. They have already a lot of things to do. The Court of Appeals is already busy with all the other things they have to do with their time. They simply don't have time for your bullshit. And so, go to court, have your trial, and if you're convicted, then, let us know all about it, and we'll let you know how it works out for you. Probably not well, but we'll let you know eventually, but not now. So that's the thing. All right, so this motion will be denied. There is a lower chance of this being granted than the underlying Franks motion being granted. That's how bad his odds are. There's a lower chance of this being granted than the underlying Franks motion. And then, of course, we can also, as a result of this, conclude that Nick Rekieta has not struck a plea deal. Because if he had struck a plea deal, his plea deal would almost certainly require him to give up his rights of appeal, because that's a pretty standard provision in a plea deal, right? There are sometimes some exceptions to that. Sometimes people do preserve the option to an appeal in a particular issue, and sometimes they actually win despite that, which is odd. But 99.9% of plea deals, you give up all your rights of appeal because, that's, you're just pleading guilty. So you're confessing to the crime. So, so we can infer that there is no plea deal. There has been no plea agreement, because if there were, he wouldn't be filing this. He would be barred from filing this. And he wouldn't want to file this because he wouldn't want to undo his plea deal, because it would be a violation of the plea deal. So he has no plea deal, which means that all of his statements he's been making on Twitter about using drugs and using cocaine and using a mountain of cocaine and all the rest of it, all those statements can and may be used against him in a court of law, should the attorney wish to use them in a future proceeding. So he has damaged his case with no protection, and he's filing an appeal that has no chance of going anywhere. That's what's happening.